Good morning. May it please the Court, I'm Richard Shea for the appellant Darrell Sharpe. As I'm sure the Court is aware, by the time this case got to the jury, about the only issue for the jury to resolve was the state of mind of the defendant when he inflicted severe blows to the head with what apparently was a hammer and killed her. The judge instructed the jury on all three theories of first-degree murder, as well as second-degree murder, voluntary manslaughter, and as well as excessive force and self-defense.
He was convicted of felony murder as well?
Yes.
What was the predicate felony for felony murder here?
Robbery of the victim.
The computer, the money?
Yes. The prosecution's theory was that she would not. He made demand upon her to give him value so he could pay off a court fine on that day, and she refused, and he killed her.
And that was all based on the statement of a witness who had repeated a conversation that the witness had with the victim, that she was going to get a new apartment and move out, and he was trying to get money from me, and I wasn't going to give it to him.
Yes, that was.
Or at least that was a significant part of it.
Part of the evidence, I think. The circumstantial evidence was that he did, in fact, after the killing, he did take various things and reduce them to cash and spread a lot of the cash around. So
was there any evidence
that there was certainly after the fact there was show that he took her. The evidence was that he took her possessions. He denied that they were her possessions. But
was there any evidence that, at least a statement that she had made, talked about he wanted to get money through a student loan that she had had?
Yes.
Was there any evidence that she had had cash, or was there any evidence that she had recently drawn down or obtained a student loan?
I don't think anything more than the hearsay that was her friend testified to.
What about the fact that the murder occurred on the day that the restitution was due, and the fact that just before the murder, the defendant called a cousin of his, Mr. Bosch, I guess, whom he hadn't spoken to in a long time, and he was looking for money from him?
Yes, well, that's a circumstance also.
And then
I'm not denying there were circumstances after the fact that tended to
reflect
back to his state of mind at the time of the killing.
But this wasn't after the fact. This was before.
I'm sorry, you're right. Yes, yeah, you're right. Bosch was before.
And also the fact that the murder occurred on the day that the restitution was due.
Yes, that's a circumstance as well.
Same.
Yeah. The defendant testified, and the defendant testified that the way the fight occurred was over him coming home at 3 o'clock in the morning, drunk, and the victim accused him that morning when she got up of being with another woman, that she was fed up with him, and he had to leave. He said he wanted to take his belongings. She refused. She went at him with the hammer once and missed, and then he was in the toilet, and she came in, yelled an obscenity, and started swinging at him with the hammer and hit him twice, I believe. And at that point, he stated he went into a rage, and he grabbed the hammer from her and then inflicted the blows to the head, which killed her. So if the jury would believe his version of events, you have at least voluntary manslaughter, possibly simply a reduction to second-degree murder from first-degree murder if his state of mind was merely a rage that occurred in the course of an argument and not robbery and not premeditated murder. My principal argument this morning is that the evidence that the Commonwealth produced was unfairly and hopelessly skewed in the favor of showing that for a 10-year period, the defendant with this woman and with various other women had a violent and abusive personality, which he acted upon. And the various pieces of evidence came in each time over the objection of the defense attorney. The most egregious, I believe, is the oldest. This homicide occurred in January of 2001, and he was living with a woman named Patricia Puckerin from 91 SJC-08986. And the Commonwealth called her as a witness and had her testify to the fact that during the relationship with him, he had gotten physically violent with her with his fists 10 to 15 times. And at the end of the relationship, in front of her daughter, he had pulled out a knife and held it to her and threatened to kill her and everybody else.
Do you think that the similarities in some of those circumstances, that is, the end of the relationship, pulling out a potentially lethal weapon, and at least assaulting the woman, mitigates against the fact that it was, 6 or 7 years before? In other words, the specificity of the common details.
Yes, I agree. I think there's a balancing test that the judge had to apply, which this court also has to apply on reviewing his decision, which is, as you call it, the specificity of the facts of the prior bad act and how they fit the current bad act, as well as the period of time, and the length of time is a factor. And then, of course, it's prejudice to the defendant. In the overall scheme of things, how unfair is it to bring this in and have the defendant defend against what he was doing with Patricia Puckering from 10 to 6 years prior to the homicide of
What about our
Vinchetta Meyer.
case of Commonwealth versus Rosenthal, which admittedly was with the same person? It was with the defendant had been hostile to his wife 5 years earlier. And we said that that was all right because it was relevant to show the nature of the relationship and the volatility of it, because there were at least some acts closer in time that made these more remote acts relevant.
Well, that's the same relationship.
But here,
This is a different woman.
but was it probative to show that the defendant's relationship with women, whenever he entered a relationship with a woman, it was they would get into arguments over money. He did it in all the 3 relationships, including the one with the victim in this case, and it looked as though he was starting a relationship with a new woman right at the same time. So there's this string of relationships. There's a scheme of living off of women that might be very relevant in this case. What do you say about that?
Well, that was the theory in which the Commonwealth presented all of this evidence, in which the theory which it came in was a pattern of conduct. It was the exception to the prior bad acts rule, which was the reason it was allowed in. And my argument is that the general characterization of a man living with a woman and having arguments and sometimes being violent and having fights about money and infidelity is something that is so general to the human population that in the case of a lot of men, it probably would be possible to delve back into their past and show that they had at least shown physical violence with their fists against their domestic partner. My argument is it's just too it's too generalized in terms of his character.
Doesn't this go one step further, though? He's living off of all these women.
Well, he was working too. He had jobs off and on.
Okay.
And he wasn't just completely living off them.
Okay.
There were fights about money. He wasn't contributing enough to the domestic situation, but he wasn't just completely living off them. The one case that I mentioned to my sister.
How did the Puckering testimony come in? Through her? Did she testify?
Puckering, yes.
She came and testified.
She testified, yes. She was a Commonwealth witness. I mentioned the Braskulis case. It's not in either of our briefs, and I'll cite it in a 16L letter. In that case, the defendant was charged with sexual assault of a woman who was jogging along the Charles River, and the Commonwealth produced proof that on 2 prior occasions he had accosted women in a sexual manner, and that was supposed to show a pattern of accosting women in a sexual manner in public. And this court held that it was, the specificity was not sufficient. It was too much of a general assault of character of the defendant that was being shown. And I think the language that's in that Braskoulis case is very helpful when applied to this one as to why particularly the Puckerin episode so many years before was just too much of his general character.
If you're right, wasn't this case so overwhelming against the defendant that the point is lost?
No, I think it might put it the other way around, that the defendant's only defense when he testified was, and as his attorney tried to pull out of all this evidence as it was going along, was just that he had a nagging relationship back and forth with the woman whom he killed, and this was just another part of the give and take, and it wasn't. And he testified to that when he testified. That's what the argument was about, was another woman, him coming in drunk, and she telling him, "Get out! Don't take your belongings." It wasn't. It wasn't everything else that the Commonwealth tried to show by reason of Patricia Pucker, and then there was another woman, Deborah Jones, that they got into evidence that in 93 or 94, she had gotten a restraining order against him. That's all we know, a restraining order. Then we have four restraining orders that came in. The victim in this case, Vincetta Myers, got in against the defendant in 95, 96, 96, and 97. All of those just came in as bare restraining orders, and they were that many years before the homicide in this case. So,
Christie doesn't deny
in that case, I haven't found any case more than 2 years prior to the episode in which the prior restraining orders were allowed to be admitted.
Let me just ask you this. When you said that the defense was sort of, this was just, there was this history of a nagging relationship back and forth, was that trying to meet the fact that you had this string of 209A orders way back, going way back in time, or was that, in other words, if that was the defense, one could see that those prior orders might actually be helpful to the defense because it shows that there had been orders, they had been abandoned, et cetera, et cetera, et cetera. I just don't know how it came in.
As it came in, all that the orders showed was that there were 4 restraining orders issued against him at her behest. No other information concerning them. There was no limiting instruction that came in with that. The only limiting instruction about the prior bad acts testimony came at the very beginning after the victim's son testified to arguments between the two of them. And the judge generally stated that the prior bad acts testimony was to be considered only on the issue of the pattern of behavior, and it wasn't to.
Was that repeated in the final instructions?
The final instructions were simply you are to take this for the reason that it was let in, and not take it as proof that the defendant committed the crime in this case. If I might paraphrase it.
Did defense counsel argue in closing that all these prior incidents really are supportive of the defense that he lost it on this particular day?
Yeah.
So he argued it to his advantage.
He argued that about the relationship with her. I don't think he got into. I don't recall him getting into.
I thought that the judge said in his final instructions to the jury that they weren't introduced to show bad character or that he was guilty. I thought that the judge did say that.
Yeah,
I haven't read the transcript, but
the final
in his instructions to the
yeah,
jury.
But what they were to be used for was a general statement that they're to be used for the purpose for which they were admitted at the time they were admitted.
Well,
And which
well,
refers you back to what he said at the beginning of the
right,
case,
but it would be
which was it's just to show a pattern of conduct. And my point is that it's an unfair pattern of conduct. And the restraining orders, the point I want to make is the jury didn't know. They're hearing about Patricia Puckerin and pulling a knife on her at the end. And then the next thing they know is he's Deborah Deborah Jones has got a restraining order against him, and then Vincetta Maya's got 4 restraining orders. They don't know what the restraining orders are. The restraining orders should come in under the case law, as I understand it, only to show hostility between husband and wife, man and woman, and therefore they should be considered only in a short period of time prior to the incident that he's on trial for. In this case, what they're using them for is the unpermitted purpose of showing a pattern of conduct that's similar to what he did with Patricia Puckerin or Deborah Jones, whatever he did with Deborah Jones. The jury doesn't know what he did to these to merit these restraining orders.
Were
That's
the
one of
affidavits, are the affidavits marked for identification?
The affidavits were marked as Exhibit A for identification. They
Why
are
did you
quoted.
want, yeah, why did you want the affidavits in? I didn't understand that.
They are quoted in the transcript after it began. It's quite a long discussion at sidebar. Begins at transcript volume 3, 135, and continues on. The defense attorney he quoted from 2 of them, and he paraphrased the other 2. And the reason he wanted them in was to show that in one instance, the victim was giving it back to him. He destroyed her property, and she turned around and destroyed his property. And in other instances, it was just ordinary domestic fighting and squabbling rather than violence. I think only one occasion did she mention using his fists against her. There was no deadly weapon.
He was not permitted to put any of that in?
He was not allowed to put any of the affidavits in with the restraining orders.
Or in any other way get into what the facts that they were alleging?
No, the judge told him, bring it out on cross-examination of your defendant, and to the extent he could, he brought out what the history of their relationship was. But the argument is that this is, and essentially this is hearsay in this case, but in the case where she was offering it, it was reliable as a statement of a party to be considered by the judge that issued the restraining order. So my point is there's some reliability there. And the general rule of completion of a statement.
But they're not written by the orders aren't written by the same person who writes the affidavit. They're not at the same time. They're not written at the same time. And I don't see why they're not hearsay.
Well, it is hearsay in this case, yes. But it wasn't hearsay in that case. So I'm just arguing that there's
That case, what's that?
The restraining order case. The judge was able to consider the affidavits in the restraining order case, despite the fact that they were out-of-court statements.
This is this case.
I know, but in a sense, I'm just arguing reliability. I'm not saying that it's a complete exception. And the reason that it should come in, at least with a limiting instruction, is number one, it's reliable, and number two, it's completion of the picture. The defendant was unfairly limited to having just these restraining orders come in with the judge's instruction at the beginning of the case that these things show a pattern of conduct, but he wasn't able to show what the woman was alleging when she was getting the restraining orders. They just are there on the table. Here's the restraining orders. Was he pulling a knife on her each time? Was he using a deadly weapon, like with Puckerin, or not? The argument is it would have been a fairer way to consider the restraining orders if they had seen the had seen the affidavits back.
Your point is that if we're talking pattern of conduct, you should be able to explore what the conduct was that is alleged to be the pattern.
Yes, and instead the restraining orders came in for more than what they should be come in for. They shouldn't come in to show pattern of conduct to begin with. They should come in to just show recent hostility between the parties.
Now, what do we do with the fact that the judge referred to these affidavits as brutal for the defense case?
Well, that was the judge's opinion, and the defense attorney said it's a tactical decision on my part that this is the defense that I'm presenting, that these two gave it back and forth to each other. And sure, he's admitting that he gave it to her, but she was giving it back to him. I think of pretty much covered the points I wanted to make concerning those issues, and my time is up, so I'll done. Thank you.
Good morning. May it please the Court, Laurie Yashulis for the Commonwealth. The Commonwealth is asking this Court to affirm the defendant's conviction for first-degree murder under all three theories of extreme atrocity and cruelty, premeditation, and felony murder. Commonwealth is also asking that you affirm the motion judge, who is also the trial judge's denial of the defendant's motion to reconsider the denial of his motion for new trial. I'd like to start off by addressing the affidavit issue, since we've just discussed it. And it's the Commonwealth's position that those affidavits were hearsay, inadmissible hearsay. It is also our position that the defendant had shown no reason why they would be permissible under the hearsay rule, other than the argument of doctrine of verbal completeness, which Justice Cowan has stated is inapplicable here. They were not the same writing, not at the same time, and therefore the doctrine of verbal completeness is inapplicable. And I might add...
Let me stop you. I mean, I've not read the affidavits, but is there not some substance to the argument that if the Commonwealth wants to offer the 209As to show a history of violence, that it's appropriate for the other side to offer the affidavit to show that there's really less to that than meets the eye?
Well, there's two answers to that question. First one is yes, and the judge allowed them the opportunity to do that through direct examination of the defendant. The problem for the defense is when trial counsel sought to do that, the defendant admitted that he had served 3 months in the House of Correction on admitting his guilt in one of the instances, so trial counsel ceased the questioning. So he was able to get that information
But
out.
it's very different to have the defendant testifying with all the issues of the defendant's credibility
Correct.
writ large, and having the victim's own statement as to why she was seeking the restraining order be available.
Which is why this judge engaged in his discretion, looked at these affidavits and said, I don't see how these are going to help you. They would be brutal to your case. And he engaged in a conscientious and thoughtful...
But he kept them out. He didn't. That isn't why he kept them out, is it?
He excluded them on two grounds. Well, he said on the record that he excluded them because they would be brutal to the defense case, but also on hearsay grounds. They are not like the restraining order in that the restraining order is kind of like a business record type written by the court on order of finding by a judge. These affidavits are hearsay written by the victim. And I might add, in the second part of your answer to your question is, here there was evidence that the relationship was troubled, that there was give and take, and the purpose for the defense counsel, trial counsel stated on the record for getting these affidavits in was to show the jury that the victim was the aggressor in the relationship at times. That evidence was already before them. Was before them through one of the Commonwealth's witnesses, through testimony of Ms. Gilpin, who testified that at one point the victim had chased the defendant down with her car. So the evidence that the victim was the aggressor at times in the relationship was before the jury. There was also evidence through the defendant's witnesses that the victim was not afraid of the defendant and that she gave as good as she got. So this evidence was merely cumulative. So at this point, to show that the exclusion of these affidavits was prejudicial would be very difficult in this case.
Going back to the point that it was enough for the defendant to testify, I don't know how he could. I mean, if the questioning were asked of Mr. Sharpe, what did the victim say in her affidavit to the court? Wouldn't it be hearsay for him to answer that question too?
I'm sorry, please repeat.
If he takes the stand, which he did, and if the question of Mr. Sharpe were, what did the victim say in her 209 affidavit back in 1995 or 96, that's hearsay too.
I'm not entirely sure that would be the question posed. My understanding was that the trial counsel would be allowed to direct him on, were these instances accurate, and he could answer them yes or no. And he also could answer, the bigger picture is he wanted to show that she was the aggressor. That information was before the jury. The admission of these affidavits, I don't see how we don't have the affidavits, and I don't see how, especially on the judge's findings that they would be brutal to his case, could help him there. So the judge is exercising his discretion by excluding them in this instance was to help the defendant by not putting these instances before the jury.
Is that really the judge's role? I mean, he does have a counsel who wants to put them in.
I understand that, but the counsel, when asked how do these meet some exception to the hearsay, his response was, well, if the Commonwealth gets to put in the restraining orders, I'd like the affidavits to come in because I want to show that the victim was the aggressor. He also wanted to show that the defendant lost control.
Well, was there any theory of self-defense advanced at the trial?
In reading the transcript, trial counsel had stated, I'm really not trying this on a self-defense case, but it was there to, he did request the instruction, he did receive the instruction. The facts of the case, according, even if you look at the defendant's point, the argument starts at some point in the bedroom. She comes after him with a hammer. He holds her down on the bed. He takes the hammer away from her. He puts it on the nightstand. He goes into the bathroom. While he's in the toilet, she comes in, and it's his testimony, which is rebutted by the Commonwealth's witnesses, that she swung the hammer at him. The transcript's unclear from his testimony how they end up back in the bedroom.
Well, doesn't he claim that he was struck and had a contusion on the left leg?
He claims that in his testimony. However, when confronted with the Commonwealth's rebuttal witness, the jury were left with rebuttal evidence that he says he was hit in the leg on January 3rd or 4th when the murder occurred. He's in the hospital on January 7th through the 9th for a possible drug overdose. The nurse who's treating him there, we offered on rebuttal to show when he was there on the 7th, outside of the drug overdose, he had blood on his hands, under his cuticles, on the palm of his hands, in between his fingers. She did a full body review of him to see where was this blood coming from because it was dried and she wanted to see a cut to attribute to it. She noted an old abrasion on his leg. When he's arrested on the 19th.
So there was no evidence of a fresh wound to his leg?
No. And in fact, the nurse testified that when she looked at the photograph of the defendant's injury taken on the 19th by the police, she said that injury was not there when I treated him on the 7th. So his testimony was rebutted by the Commonwealth's witness. I'm a little off track. So if I could, I'm not sure about the affidavits. The bottom line is the point that the trial counsel wanted to get forth was that he was aggressive. He got that evidence for us. He had people testifying that he had a short temper. So the evidence that would have been contained within those affidavits was before the jury. This would have been cumulative. It was hearsay. It was inadmissible, and it couldn't have been considered substantively anyway as a matter of law. I also would like to...
let me ask you, I know that we have cases, primarily Commonwealth versus Gill, which say that the restraining order itself is admissible, but and it's admissible to show the relationship between the victim and the defendant. But I'm wondering why the 209A order itself isn't hearsay.
The 209A order itself? Well, under our case law, the 209 orders are admissible to show the hostility between the parties. There's several cases. It's not just the Gill.
I know. Well, the other cases cite Gill, but evidence still has to be non-hearsay that's probative.
Well, nothing in the restraining orders are hearsay. They're orders by a court. What makes them admissible is it's probative of the relationship, and a lot of times we allow them in murder cases for the simple fact that the deceased is not able to testify. And there has a history or a pattern or the nature of that relationship can be, these restraining orders are probative of that nature. It's not dispositive, but it's probative. And in this case where we have 4 restraining orders, 95, 2 in 96, 1 in 97, and then you have testimony in 98, 99, Ms. Gilpin sees an instance between the two where the defendant's pulling the victim out of her car. In May 2000, on Mother's Day, she witnesses a day-long argument where the defendant's eventually grabbing the victim by the face and forcing her to look at him. I mean, these are all a pattern of the defendant's hostility toward this victim. And going back toward Ms. Parkering's testimony and why that's...
Does it matter what level of hostility it fits the pattern?
The level of hostility. I think a growing animosity between a defendant and a victim's spouse is
So how do we know,
of motive.
how do we know that the restraining order wasn't just kicking a bucket that hit her?
Well, under the 209A statute, the person requesting the restraining order has a certain level of guidelines that she must meet. She must say she's in fear of this person. She must state instances from which a judge can make the determination that that the restraining order should issue. It's kicking a bucket, I don't think would make the case under 209A. So there
Are you telling me that has never made the case?
I'm not, I don't think that it's ever made the case. There are guidelines in which the judges must follow in issuing a 209A, and kicking a bucket, I don't think one. The victim must state that she's in fear of bodily harm to herself from this person that she's seeking a restraining order against. It's not arbitrary. There are objective standards that the judge must look to and prior to issuing a restraining order. I want to talk about the Bruscalis case that my brother mentioned, and in that case, that was an issue of similar acts to prove identity. We don't have that question here since the defendant's identity was never an issue. The acts of puckering that were introduced in evidence were admissible to show that in instances in a relationship in a narrowly focused instance, when the defendant is in a relationship, when he's living with a significant person in his life, and they continually fight over money, and when those fights escalate and come to a crescendo, and in Ms. Puckerin's case, she ended the relationship. In the victim's case, she's ending the relationship, and the fighting is all about money, he resorts to violence with a dangerous or deadly weapon. In Ms. Puckerin's case, it's a knife. The victim's case, it's a hammer. In Puckerin's case, he also threatened to kill her.
Are you suggesting that's relevant regardless of how much time passes?
No, time is important. I'm not suggesting it's not. But the difference between days, hours...
And with Ms. Puckerin, how many years prior had that situation been? Was that 10
With the
years?
knife? The knife situation happened in 1994. What's interesting in this case, when we look at remoteness, and the trial judge found this, the relationship with Ms. Puckerin ended in 1994. The relationship with the victim started immediately thereafter, soon right after. The relationship started with the victim through her son's testimony with fights over money. So we don't look at remoteness here as far as years. I don't think we can look at that here. I think we look at relationship ends, the nexus of the next relationship begins. His pattern continues. His pattern was with Ms. Puckerin to fight over money, resort to violence when the relationship ended. His pattern continues. 95, 96, 96, 97, 99,
Wait.
2000.
Why do you have a pattern?
The pattern of fighting over money came in through several witnesses. The victim's son said, who lived in the home with the defendant and the victim, said that they fought constantly about money. The defendant's witnesses themselves said they fought constantly. So the pattern was the fight against money. The pattern then ends when the relationship ends, the defendant resorts to violence, wielding a deadly weapon. So that's why Puckerin's testimony was admissible to this defendant, to show that pattern, to show the similarity. When faced with a similar situation, the defendant acts similarly.
I guess I'm just not sure how far back you can go. Even assuming that there was a pattern of problems with relationships around money that involved, that culminated in some kind of violence. Could you go back 30 years?
Well, respectfully, the trial judge did review this in a motion in limine here. He did look at all this evidence, and he did make the determination. He did state on the record that I'm reviewing this probative versus prejudicial, and he stated on the record here, where it does show a pattern, remoteness is not so much a concern. And I think the case law would support that when it shows a pattern of behavior with women in a focused and specific circumstance, that the time element is not as critical as the pattern.
If there had been a long-term relationship between the defendant and yet a different woman that was sandwiched in between his relationship with the defendant and his relationship with Puckering, whatever her name was,
Correct.
and this intervening relationship was not characterized by any hostility, would the events from the Puckering relationship still be probative or admissible?
I'm not so sure that the judge in this case would have allowed it in, but in this case we didn't have that instance. We had relationship to relationship, and in fact, if you go back to Deborah Jones, we have relationship to relationship to relationship, where there's a pattern of this behavior. So in this case, I think The years are not so as important as the pattern of relationship to relationship to relationship. So I think when we look at remoteness, we can look at remoteness in time, or we can look at remoteness from relationship to relationship. And in this case, and the judge exercised this prejudice versus probative review and found that it was probative of pattern. I'd also like to address the fact that each time bad act evidence came in, other than the time that the defendant did not object to it, there was a limited instruction by the judge. In fact, in the morning of the second day of trial, the judge, sua sponte, gave an additional limited instruction to the jury that they're only to look at this evidence of prior bad acts on the issues of intent, motive, pattern, course of conduct. He also gave the final charge. He said, aware that they had heard evidence of prior bad acts, he said, you may not consider that on evidence of guilt. It is not probative of, you may not substitute that for proof of guilt.
There was a conversation that was admitted in evidence, or there was evidence of a conversation that was admitted, and the witness who testified had spoken to the victim shortly before her death, and reported that the victim told her that she was getting a new apartment and the defendant wasn't coming along, and that the defendant was going to he was trying to get her to give him money for this restitution obligation that he had coming up. One of the things that you have to show is, if it's going to come in as the state of mind of the defendant, is that the defendant knew about this conversation, knew about this problem that she was talking about, and you showed that he knew at least the component about her moving out. She was going to get another apartment because he went to his cousin Bosch and said to him, "I'm having problems with my girlfriend, and can you help me get an apartment?" So he was at least aware of that part of the conversation, or there's evidence that he was. But where's the evidence that he was aware of that part of the conversation having to do with what the defendant said he demanded money?
Let me clarify that to you. The victim said to several people that she was looking for a new apartment, that she was through with the defendant. We know that the defendant was aware of that because he went to a friend, Askiat, I can't pronounce it.
Yeah, that's not the problem. The problem is the money.
The money is, in the days and weeks leading up to the murder, he's frantically calling his cousin Bosch. And he's saying, I need money for a court fine. If I don't have it, I'm going to go to jail.
Yeah, but where's the evidence that he had talked to her about needing money?
The evidence comes from the fact that it's no coincidence that she's murdered on the night before the money is due.
But that doesn't mean he talked to her about it.
I think it's inferentially.
Can you infer that from the fact that the victim's son said that they were always arguing about money?
I think that's partly, yes, the victim's son does testify that they're always arguing about money. I think you can also infer from the fact that his
when was
actions after.
the defendant was committed to DYS?
He was.
Or
No,
her son was. How long had he been at DYS?
There's testimony that the defendant knew that he was in DYS custody since Thanksgiving.
So for 3 months?
November, couple of
2 months?
Yes. Month and a half.
So he didn't know what the nature, he didn't even know that they were living together, did he? During that period of time?
He lived with his mother and the defendant off and on from 94 going forward.
No,
so
I'm talking about he was committed to DYS.
for a few weeks prior to the murder, yes, he was.
And was the defendant living with them at that time?
He was.
All three of them together?
Yes, they were. By the defendant's statements to police, he was living there, even though he knew he was not supposed to be living there.
And what about the fact that the murder was committed on the day the restitution was due?
Well, that's no coincidence, Your Honor. The Commonwealth's position was he had been asking her for this money all along through her statements to other people, and that it came to a crescendo the night before the money is due. There was testimony that he had been hounding her for her student loan money to pawn her computer, and she was refusing to do so. His frantic calls to his cousin, his cousin's testimony was, these are 10, 15 messages left for me over a couple days. I finally speak to him on January 3rd, the day before it's due, and he's very persistent in making these phone calls to me. He's frantic. He's very concerned. He wants this money. He needs this money or he's going to jail. So I think you can, taking those frantic phone calls to his cousin, and he's been living with the victim who's been supporting him all these years, I think we can infer that the defendant knew the victim wasn't paying for this restitution, and he was frantically looking elsewhere for this money. And I think you can make that inference based on those phone calls.
Is there any evidence, I know there was evidence that he tried to sell a TV and a computer. Is there any evidence that the TV and the computer that he was trying to sell immediately afterwards came from the victim's apartment?
The only evidence we have is that on New Year's Day, the victim's sister sees the computer and the printer on the table. After her murder, it's no longer there. The defendant says he doesn't know what happened to it.
But he said it was his, didn't he?
He said one of the computers. He said there were two. The one that he tried to pawn was his, but it's missing, and he's the only one in the apartment. But he has no explanation for its whereabouts.
Are both of them missing?
There is no testimony on whether or not both of them are missing. And he does say he did say he pawned a television set, but said it was his. But we don't have any evidence on whether it was his or hers.
Thank you, counsel.
Thank you.
SJC-08986, Commonwealth versus Ridge.